Hello, my name is Loretta McElwain,
And I'm Sarah Somerville. We're co-founders of Smart Feds Law Group.
and today we'll be talking about four venues that are available to federal employees when they have a complaint or a grievance. Everybody's mostly familiar with the EEO process, but there are others. And today we're going to cover four to help you decide which one may be the better one for you. So let's go ahead and get started with the grievance process. Sarah, what do people need to know about the grievance process?
Well, the first thing you need to know about the grievance process is you must be in the bargaining unit to file a grievance under the collective bargaining agreement. If you're not in the bargaining unit, you may file an administrative grievance if that agency has a policy for administrative grievances. So you follow the process in either the policy or the collective bargaining agreement. Make sure you follow the timelines in each one of the different steps of a grievance. A grievance will usually have an informal stage, and that's where you sit and talk to try to resolve the matter. If you can't resolve it that way, then you can file the step one or step two, and most grievances will go all the way up to step three.
So I have a couple of questions. The first one is what kinds of issues do people normally file through the grievance process?
Any work-related dispute with the manager, um, like performance appraisals. Uh, People like to appeal the decision of their appraisal. Uh, if there is a suspension of some sorts, or they will file a grievance for that. But anything you are alleging violates your contract, the collective bargaining agreement. Hours of work, if you're written up for an issue or matter regarding conduct or work performance. Usually it's conduct and work performances. That's where you see grievances.
Okay. And when you say if I'm covered by the bargaining unit, that means that my position is covered under the bargaining unit. But what if I don't pay union dues? Am I still covered under that process?
Absolutely. Even if you don't join the union and pay dues, you're still covered under the grievance procedure. And you can tell by going to your SF50. There is a block in the SF50 that will indicate whether or not you're in the bargaining unit.
That's correct. I don't remember the box number, but I know it's called BUS, bargaining unit status. And if that box shows 8888, it means the bargaining unit designation does not apply to you. So if you're a supervisor or you're in a category that is not covered under that bargaining unit, it will show that number. And if it shows another number, then it typically means that you are covered under the bargaining unit. And you can probably always check with the union steward to see if your position is covered under the bargaining unit. Yeah.
That's correct.
All right, great. Let's talk about arbitration.
So if you don't settle the grievance through the second step or third step, whatever your final step is, the collective bargaining agreement will allow you to go to arbitration, to take your complaint further to a third party. Now, only the union president can invoke arbitration on behalf of the union. And on the agency level, only the general counsel or a designated management representative can invoke arbitration on behalf of the management side. But the union can decide to challenge the agency by invoking arbitration. And a lot of people do.
Is arbitration voluntary on both ends when one party invokes it, or if one party invokes it, is the other party required to participate?
Um, yes. Um, both parties will be are required to participate in arbitration.
So let's move on to the equal employment opportunity or EEO process. I think that one most people are familiar with, but I think there are probably still some nuances that we want to share with people about the EEO process.
Well, if you believe you have been the victim of discrimination, you have a right to file an EEO complaint with your Office of Civil Rights. You need to initiate the complaint by contacting the Civil Rights Office at your agency within 45 days, calendar days, from the alleged discrimination. It's very important to not miss that timeline. The EEOC office will assign a EEO counselor to you, and that counselor may offer you mediation or as an option to settle the complaint without going further. And if you're not able to settle it, settle with the counselor through mediation, then you will have a right to file a formal complaint. And you will be issued something called a notice of the right to file a discrimination complaint. And when you get that record, when you receive that, you know you can go ahead and file your formal complaint.
Okay. Um, so those formal complaints eventually, if they're not resolved, end up before an administrative judge at the Equal Employment Opportunity Commission, and that judge will decide either in favor of the agency or in favor of the employee. What happens when one of the sides is not happy with the decision?
Um, Before we answer that, go back to notice. The notice of the right to file will lay out to you all of the process that you need to know. The number of days you have to file and who to file it with. All of the process and procedure will be in that notice. Now, I believe your question is if you don't win your arbitration or your EEO complaint with the EEOC, what are your options? You have a right to appeal to the U.S. Federal District Court, with your EEO complaint. You can go all the way to the Supreme Court with an EEO complaint, but true, definitely you can appeal to the courts.
Because an EEO complaint is a lawsuit against the federal government, even though it starts as an administrative matter, it can end up in court, and a lot of times it does. So, is it a good idea to have a lawyer in all cases?
Um, you know, you're not required to have an attorney before the EEOC. Most people do. Before they get to the EEOC hearing, they've already hired an attorney. But no, it is not required to have an attorney. You can ask anybody to represent you, or you may represent yourself. But it's good to have one if you're going to go into U.S. federal court, because the court's going to be following the rule of civil procedure, and most non-lawyers will not be familiar with the rules of civil procedure. So you're at a disadvantage if you're going up against an attorney.
Okay, that's good information to know. Let's talk about the Merit Systems Protection Board, or MSPB, and that process.
The Merit System Protection Board is where you go for an adverse action. Um, if you want to challenge the agency's actions such as a removal, a demotion, a suspension, violation of merit system principles for your whistleblower protection, your veterans reemployment rights, all of that. You challenge those appeals before the MSPB. And you generally must file your appeals with the MSPB within 30 calendar days from the effective date of the adverse action. You have the option at the MSPB to file electronically online, or you can send it by certified mail. You can have a delivery person deliver it to the office, and you may also fax the appeal over.
So let's say that I was removed from my position, meaning I was in essence terminated or, or fired, whether it's for performance or conduct. And I believe that I was fired because of my race, sex, national origin, religion, disability, one of the 10 protected classes. I would take that complaint to the EEOC. But let's say that I think that I was wrongfully terminated, but I don't think it was because of race, sex, national origin, or one of those things. Let's say I instead believe that the agency didn't follow procedure or that I wasn't treated fairly according to the merit systems principles. That's when I can go to the MSPB.
Right. You can take a mixed case to the MSPB, one that challenges the removal and another one that challenged the discrimination as well. So yes, you can go to MSPB, the Merit Systems Protection Board, for a mixed case.
Okay. And just to clarify again, the mixed case is basically the same situation, in this case, being terminated, uh, because of race, sex, national origin, whatever the situation may be, but also because I believe that a merit system principle was
Was
violated.
violent.
And
Exactly.
is it possible to prevail in one argument and not in the other?
Well, I guess it may be. Um, you may be able to prevail on one and miss the other one. But you generally do need to select a venue. You need to choose a venue, and you can't file in multiple venues. So the MSPB, in my opinion, would be the best place to file that case.
What happens if I'm not aware of this and I happen to file the same issue in both places instead of filing a mixed complaint?
Um, the attorney, the agency attorney, will likely file a motion to dismiss one of the complaints from one location. So that's their job to catch that.
Mm,
And
okay.
that is filed, and the same issue was filed at EEOC that was filed at MSPB. So they would generally file a motion to dismiss.
Okay. All right. Yeah, that makes sense. So
Mm-hmm.
if somebody has an issue, whether it's an adverse action like a removal, a termination, a RIF, or another type of adverse issue, lowered performance, they denied reasonable accommodation, whatever the situation may be, how can Smart Feds Law Group help them?
Oh, we provide guidance in selecting venues. We're really good at that. We will provide expertise to managers, employees, union officials. We can assist you with any grievance or any third-party litigation or before an arbitrator, before the Equal Employment Opportunity Commission, before the Merit Systems Protection Board. Also, we can provide services before the Federal Labor Relations Authority, the FLRA, and before the impasses panel.
Mhm. So if I'm not sure which one applies to me, or if I have questions, I can come for mentoring and coaching, and you will help me figure out strategically what makes sense in my specific situation, and whether I should hire a lawyer and at what point I should hire a lawyer.
Absolutely. Just go to our website, www.smartfizz.net, complete a consultation form, or give us a phone call, or send us an email. But information is contained in the website as to how to get in touch with us, and we will be glad to sit down with you for a consultation and help you determine what's the best venue for the case you have.
Right. Well, that's all we have for today. If you found the information in this video useful, make sure to like this video, subscribe to our channel, and share this video with others that may need to know this information. Thank you for listening. Stay smart, stay strong.